Alrighty.
Yeah.
Well,
And, if Mark doesn't pop out, I will make eye contact with you and I'll do it.
alright.
So you'll be taken care of no matter what.
Perfect. Oops.
They
It's
are
okay.
just finishing up the miking up.
Okay. That's fine.
So you've only been here for
A few minutes.
6-7 minutes.
Yeah. Nah, it's fine.
Be okay. Is this mic live?
Yes. Yes.
Picking
Confirmed.
up just a little hint, when you press the mic and you're just
Yeah.
that was too loud. I got a signal from Eric.
Oh.
That must be this. Alright, I'm gonna step over.
Hello, my name is Gabe, and I am a member of the Dole Institute's Student Advisory Board. Welcome to the Dole Institute of Politics. The Dole Student Advisory Board is comprised of KU students committed to the bipartisan mission of the Dole Institute. Members of the SAB receive many great opportunities. If you are a student and would like to join, please contact the Dole Institute. We would like to encourage each of you to get special benefits and support the Dole Institute by becoming a friend of the Dole Institute. If you enjoy this evening's program, please let us know by contacting us on Facebook, Twitter, or through our website email. Hearing assistance is available, and we have a loop seating section at each program designated by a sign. If you have any questions about the loop, or if at any time during the program you have difficulty hearing, please alert one of our staff members or student volunteers. Before we begin tonight, I would like to remind you to please turn off your cell phones. After the interview, we will have some time for audience questions and answers. If you have a question, please raise your hand, and a student helper with a microphone will come to you. Please stand if you are able and ask just one brief question. And now, please welcome Dr. Barbara Ballard.
Thank you, Gabe. We always have a student do a welcome to our students, and they do an outstanding job. So again, thank you very much. Good evening and welcome to the Dole Institute of Politics for tonight's Constitution Day program. The title, Kansas in the U.S. Supreme Court. Before I introduce our guest tonight, I will ask you to join me in commemorating Constitution Day by ringing your bells, and there are 5 on the table there for our guests, and reciting the preamble as preempted in your program. Of course, if you have it memorized, don't even bother with the program. But I will start by saying, we will ring our bells, and I will start. Are we ready? We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Thank you very much. You will also find in your program something that we usually don't have there, but 20 fascinating facts about the U.S. Constitution. And there were many more. I just chose some for you to just read. I would like to say tonight's distinguished panel will be moderated by Stephen McAllister, the United States Attorney, the District of Kansas. About our program, the U.S. Supreme Court has granted a review to 3 separate cases involving the state of Kansas in 2019, which it will hear in October and November. And when we look at this and our special guests in our panel, they will explore the constitutional issues raised in each of the 3 cases. Our distinguished panel this evening will be Derek Schmidt, who was elected the 44th Attorney General of Kansas in 2010 and was re-elected in 2014 and 2018. He is the 2nd longest-serving Attorney General in Kansas history. Schmidt served as a Kansas State Senator, representing part of Southeast Kansas, and as a Senate Majority Leader. Sarah Harrington is among the most experienced Supreme Court specialists practicing today. She has argued 20 cases in the Supreme Court and has served as counsel or co-counsel in dozens of others. She is an instructor in the Supreme Court Litigation Clinic at Harvard Law School and frequently speaks at conferences and with national news outlets about the Supreme Court. Derek Schmidt named Toby Kraus to serve as Kansas Solicitor General. He previously served as a law clerk for Judge Mary Beck Briscoe of the U.S. Court of Appeals for the 10th Circuit and U.S. District Court Judge Monty Ballot. Kraus replaces former Kansas Solicitor General Stephen McAllister, who had served in that position since its creation in 2007, and he resigned to serve as U.S. Attorney for the District of Kansas. Tobias Loss Eaton is a member of Sidley Austin Supreme Court and appellate practice in Washington, D.C. Tobias has written or co-authored dozens of briefs in state and federal appellate courts, including 30 briefs in the U.S. Supreme Court. He has represented clients in merits cases before the Supreme Court during each of the past 5 terms and has litigated in 10 federal court of appeals. Stephen McAllister is a native Kansan who grew up in Lucas, Kansas. He graduated from the University of Kansas and from the University of Kansas School of Law. Steve served for Judge Posner of the United States Court of Appeals for the 7th Circuit in Chicago, Illinois, and then for Justices Byron White and Clarence Thomas of the Supreme Court of the United States. He served as Dean of the KU Law School from 2000 to 2005. McAllister has also appeared before the Supreme Court of the United States several times. I hope you'll agree we have an esteemed panel this evening, and I would like for you to give them a very warm welcome. I now turn this program over to Steve McAllister.
All right. Thank you, Barbara. All right. So these chairs move a little bit. Be careful. So Kansas periodically has had cases in the Supreme Court. I think 4 years ago we had 2 at the same time, but this is quite unusual for there to be 3 coming up to be argued within a month of each other. So we took advantage of this opportunity to make it the focus of our Constitution Day program. So those 3 cases are primarily what we'll talk about tonight. We're very fortunate to have these 4 folks with us who are really expert and knowledgeable about these cases. The Kaler versus Kansas case will be argued on October 7th, the first Monday of October, the first day of the term, the very first case of the term that Monday morning. Kansas versus Garcia will be argued a week later on Wednesday, so the close of what is the October session of oral argument. And then Kansas versus Glover will be argued at the start of the November session on November 4th. So Kansas is going to be front and center. The clerk of the court recently told me he felt like every other case on the docket seemed to have Kansas in the name. So certainly very involved. So I thought what we'd do tonight to start things off is just to make sure we all know what these cases are about before we get into discussions and, as of course is the Dole Institute way, civil argument about some of the issues in the cases. But I was going to start with just take the cases in order, so I thought, Tobias, maybe you could start. I understand you had a big role in drafting the cert petition in the Kaler case, and maybe just kind of talk about what the case is about, what the issue or issues are that you presented, and why you thought it was important for the court to take the issue and look at the case.
Sure. So the basic question presented in Kaler versus Kansas is whether a state can abolish the affirmative insanity defense. And to understand why this is significant and how Kansas has approached this, it helps to take a step back and think about the different ways in which mental illness might affect somebody and contribute to them causing committing a crime. And I'm going to oversimplify quite a bit here, but essentially the insanity defense, as it has always historically operated, although I think we have a slight disagreement about that, pardon me, has focused on the defendant's ability to tell right from wrong, their sort of moral reasoning. But mental illness can affect a person in a variety of ways. It can cause delusions, it can affect your perception, it can affect your intentions and your motivations. And Kansas in 1996 abolished the insanity defense that had focused on whether the defendant could tell right from wrong with respect to his crimes, and instead replaced it with what's called the mens rea approach, which instead just asks whether the defendant could form the intent required to commit the crime. So, for example, if murder is intentionally killing another human being, under Kansas's mens rea approach, a person who's suffering from a mental illness could introduce evidence of his illness to show that he didn't know, for example, that he was killing another human being. The example that often comes up in the articles about this, for whatever reason, is if you were strangling someone, but you thought you were squeezing a lemon because of a delusion, that would negate the intent required to commit murder and would establish that you were not guilty. And so that is the rule under Kansas law today, that if you can show that your mental illness meant that you could not form the intent required to commit the crime, then you're not guilty, but evidence of mental illness is not otherwise admissible and is not otherwise a defense. And our view is that that is a significant departure from the way the insanity defense has historically worked and from the way that it works in 45 other states in the federal criminal justice system and in the District of Columbia. And so we filed a cert petition asking the Supreme Court to consider this question, both because it's important on its own and because different state courts considering this question have reached different answers on it. So the court granted review in the spring, and it will decide whether the current Kansas scheme is constitutional under the 8th Amendment, which prohibits cruel and unusual punishment, and the 14th Amendment, which requires due process of law.
Okay, and do you want to, can either let you or I can offer S.G. Krause up. Do you want to talk just a little bit about how the case came up, what the defendant actually did that sort of led to the dispute here?
No.
Larry, would you, I'm sure the government would be happy to talk about that, but.
Please. So the preceding to that interesting question is actually a sad case, and so I've noticed the longer I've worked on this case and I guess more tired I've become, I've somewhat become a little more emotional about it. I have 2 children at home. So it involves a gentleman named Craig Kaler, who was a Kansas kid. I was teasing Steve about Kansas State. He went to Kansas State, got a degree in engineering. He left Kansas State, went to work for a nuclear engineering outfit, got a master's in something or other out in Colorado, married a girl from Kansas, a K-Stater. They have 3 lovely children. I probably should remember their names, but I don't right off the hand. At the time of the crime, they were, I think, 18, 16, and 10. 2 girls were the oldest. They moved around as he progressed through his career. They eventually got to Weatherford, Texas, where Mr. Kaler was the city manager, or I think is a public works director down there. He applied for a particular job in Columbia, Missouri, again getting promoted to become what was eventually the highest paid public official in Columbia, Missouri. So he takes the job, going to move the family from Weatherford, Texas to Columbia. And about that time, there's a little bit of salaciousness, but his wife suggested, hey, I was contemplating having a same-sex relationship with one of my colleagues. Would that be okay? I think there's some uncertainty in the record as to how active or involved Mr. Kaler was. Ultimately, he said yes. Some indication that he wanted to either participate or watch. His reasoning, as the record would indicate, was that, hey, we're moving to Weatherford, from Weatherford to Columbia, Missouri in a couple months. This will just be her kind of short-term fling. So he moves up, I think, in July or August of 2009. The family's going to come up a couple months later. Unfortunately for him, the relationship back in Texas did not disintegrate. It, in fact, grew stronger. There's domestic instability as that is going on. It culminates, or it begins to culminate towards the end of 2009 at a New Year's Eve party where the wife and her girlfriend are displaying public affection at a party among all their friends. There was physical altercation that kind of leads down to the divorce road. She files for divorce in Columbia, Missouri. They argue about it. He allegedly bear hugs her, hurts her. She calls the cops. He's arrested at a city hall meeting, so it makes a newspaper. He gets fired. Long way winds up to November of 2009, in which they have Thanksgiving. As he's going through the divorce, I'll leave out some of the gory details, he takes issue with the daughters who kind of side with the wife, likes his son. Son spends Thanksgiving with him, wants to keep him for a little longer. The wife says, no, I'm taking her to Grandma's house in Burlingame, Kansas. So there's a handoff of the child, and Mr. Kaler wasn't there at the handoff of the child. So the wife and 3 children go to grandmother's house in Burlingame, Kansas, and Mr. Kaler cashes his last paycheck, jumps in his SUV and drives down to Burlingame, Kansas. He stalks the family, looks in the window, probably will break up here, sees the wife and the son in the kitchen, bursts in the door, shoots the wife 2 times, tells the son to leave. Son leaves, goes and gets authorities. He shoots the grandmother. She's in a chair. Shoots the daughter on the first floor, chases the other daughter upstairs, shoots her. And there's a life alert system. I don't know if you guys remember the life alert days. So there's a recording. You can hear the daughter wailing, saying, "Don't shoot me," pleading for her life, things like that. So his defense, when he gets found the next day, is that he did shoot them, but he was so mentally distraught that he was insane. And so he wanted to assert an insanity defense and procured a witness that testified at trial in his favor. The state, oddly enough, hired this defense lawyer's partner, who submitted contrary evidence. The jury, after a long trial, convicted him of capital murder and sentenced him to death. So then it went on direct appeal to the Kansas Supreme Court, and the Kansas Supreme Court, consistent with a prior decision, held that the Kansas insanity defense complied with due process.
So, and we'll get more into the issues and let these two argue more the substance of why Kansas law is constitutional or not. But so it's basically a murder case, if you will, a conviction for capital murder, a death sentence, but now before the Supreme Court is whether Kansas law sufficiently allowed the defendant to argue his mental state in that context. So let's go to the second case then, which is Kansas versus Garcia. And General, would you like to talk about what that case is about?
Sure. This is a case. It's actually 3 cases that are consolidated for Supreme Court review purposes, all out of Johnson County. All involve similar but not identical fact patterns, and the basic pattern is this: that individuals who do not have a Social Security number, some cases the record indicate, and others you can surmise it's because they're not lawfully present in the United States, decide they want to work and conclude that in order to work they have to fill out the appropriate documentation, including the Form I-9, which requires a Social Security number. Because they don't have a Social Security number, they do what a lot of similarly situated folks do. They go out into the black market in 3 different transactions and purchase a Social Security number. They then take that number and they fill out their Form I-9. There's separate ones. They fill out their Kansas tax forms, their K-4 withholding form. They fill out their W-4 federal withholding form. In at least one case, the record shows the fellow also used the number on an apartment lease, although he wasn't charged with that. So it's interesting, but not relevant to the underlying conviction. There's some quarreling back and forth. All of this is happening along about the same time. The 3 cases roughly straddle the U.S. Supreme Court's decision in Arizona, United States versus Arizona, Arizona versus United States, where the court really laid down, not for the first time, but really for the first time squarely, its interpretation of the 1986 federal immigration statute. And based on that decision, the state in all 3 cases either dropped or declined to pursue any charges related to the false number that was used on the I-9 form. The state conceded that it couldn't use the I-9 for any purpose. But the state continued its prosecutions for using the stolen Social Security numbers on the 2 tax forms, the K-4 and the W-4. All 3 cases resulted in conviction, either for identity theft or identity theft and a fraud crime under state law, making false information. That was present in one case. And folks all appealed and argued that federal law preempted the state from these prosecutions, that the federal immigration statute says we can't go after them for this conduct. That argument didn't fly in the district courts. It didn't fly in the Kansas Court of Appeals, but it was persuasive to a total of 5 justices on the Kansas Supreme Court, 4 of whom concluded that federal law expressly, sort of expressly, effectively expressly preempts, is the phrase in the statute, or in the decision. The 5th justice Justice Lukert took some issue with that phrasing and essentially says you can't have effective express preemption, but nonetheless the holding is correct. There is preemption here. It's just some form of field preemption or conflict preemption. And then you have two dissenters, Justice Biles and Justice Stegall. So the issue is whether or not Kansas is preempted from these prosecutions. I think we will probably see, there are two questions. One is whether we're expressly preempted by the statute, and the other is whether we're impliedly preempted by the statute. You'll probably see some difference of opinion between how we view sort of the framing of the issue, but essentially versus the other side, but I think that's essentially it.
Okay, and you might clarify it, so whose form is the I-9 form?
Right, sorry, I'm in the jargon already. So the 1986 Federal Immigration Statute, the IRCA, the Immigration Reform and Control Act, requires that there be a system for determining whether you or I or anybody else, citizen, lawful alien, undocumented person, is lawfully present in the United States in order to apply for a job. So when you apply for a job, unless you fit one of a handful of exceptions, for example, if you're the Attorney General and you're elected, and I set that aside, but for most of the time, if you apply for a job, you must fill out this Form I-9, which is the form that was created by the Department of Homeland Security for the purpose of implementing that statutory requirement. And it essentially requires, I mean, many of you know, you've done it, but it essentially requires the job applicant to attest to certain information under penalty of perjury. I am lawfully in the United States and I am authorized to work, and to provide certain documentation of that. And then it separately and additionally requires the employer to attest that the employer has reviewed the documentation submitted by the prospective employee, and as far as they know, it's in order. That's essentially it, the I-9, which of course is different from the IRS forms, the W-4, or the Kansas Department of Revenue form, the K-4, which were the basis of the prosecution, we will argue. So.
Okay. All right, and so then the third case we have is the Kansas versus Glover case. So since Toby's already gotten to talk, I'm going to ask Sarah if you would kind of introduce that case and tell us what it's about and what the issue is there.
Sure. So this case comes from Lawrence, Kansas, it involves a traffic stop that was about a mile from here, I am told. It involves the Fourth Amendment. I don't know what proportion of our audience here is lawyers, so forgive me if I'm over-explaining, but the Fourth Amendment in the federal Constitution provides that people shall be free from unreasonable searches and seizures. That usually requires that police, before they can stop you or seize you or look at your stuff, that they get a warrant or have probable cause. But there are some exceptions. They can make brief stops of people if they have, the standard is called reasonable suspicion. And that includes traffic stops. So they can make brief traffic stops if they suspect that there's illegal activity going on, if they have reasonable suspicion. And you might think, well, reasonable suspicion doesn't sound like a very specific standard. And you'd be right. And the Supreme Court has said repeatedly, that's all we got. We can't tell you any more about what that means. It depends on the facts. We look at the totality of circumstances. We listen to the officer's testimony about their experience and their basis for their inferences of thinking that they have suspicion of illegal activity. But we can't sort of give you any brighter line rule than reasonable suspicion. And they have said that basically it's a very mushy test. And so in this case, Mr. Glover was driving his truck at, what was it, 23rd in Iowa, is that where it was? Yes. And deputy mayor, a police officer, decided to run his license plate. He didn't see any illegal activity, didn't see anything suspicious, just decided to run the plate, which officers are allowed to do, nothing wrong with that. He got information back from on his vehicle computer that the registered owner of the car had a revoked license. And so he stopped the car to see whether the registered owner of the car was in fact driving the car, and he was. And so he let him drive off, even though he didn't have a license, let him drive away, and then the state later charged Mr. Glover with driving without a valid license. So Mr. Glover challenged the introduction of the evidence. He said, it was not a valid stop under the Fourth Amendment, and so you can't introduce the evidence, which is basically that in fact it was me driving the car. And it's an unusual case in a way for a Fourth Amendment case. because it was decided on stipulated facts. And what that means is that the parties got together and they said, let's just agree, let's write down, I don't know, 6 or 7, I forget how many it was, 6 or 7 facts about the circumstances, and we'll just agree on those, and we'll give them to the judge. And there's not going to be any testimony or cross-examination or anything like that. Normally, when you have someone tries to suppress evidence with a Fourth Amendment claim, they bring in the officer, they testify, or there's some sort of evidence presented, cross-examination. So this is unusual, and the stipulated facts basically said what I've told you. There was the officer didn't observe anything illegal. He just knew that the registered owner of the car had a revoked license, and based just on the assumption that the registered owner of the car would be driving the car, he pulled the car over. Now, the trial judge said, I don't think that's a very good assumption. She said, for example, in my family, we have 3 cars. They're all registered to me, but I only drive one of them. My husband drives one of them, and our driving age child drives the other one. So I don't think it's a valid assumption, and so I'm going to suppress the evidence. So Kansas appealed, prevailed in the Court of Appeals, and then my co-counsel appealed to the Kansas Supreme Court, and the Kansas Supreme Court agreed with the trial judge and said, that assumption standing alone, that the registered owner of a car who has an invalid license is driving the car, is not enough to make reasonable suspicion. If the officer had come in and give something else, if the officer had seen that the driver matched the demographic information that he knew about who the registered owner was. Of course, if the officer had seen the person doing something dangerous or suspicious or violating a traffic law, there would be an independent reason for the stop. But said basically you just needed some other piece of evidence. You can't just have this one assumption that's not about who's driving the car, it's about who owns the car. That's not enough. And then Toby petitioned to the Supreme Court and said, Kansas is out of step with everyone else in the country, and we said, well, not everyone else, but it is true that there is a conflict, and so the Supreme Court took the case, and I'm hoping for a lively argument.
Okay, so well, let's turn back then to Kaler and Tobias. Give the audience your. Toby's getting an assistant, somebody texting your arguments.
That's right, yeah.
So give the audience your best shot. Why is the Kansas law unconstitutional?
Well, so as I touched on, and of course this is a point of disagreement between us and the state, our view is that the insanity defense, going back literally for centuries, basically to the point when the common law first became a recognized legal system in England, has encompassed at least the defendant's moral capacity, his ability to, as the old cases say, choose between good and evil, or as we would say today, tell the difference between right and wrong with respect to his actions. And that was certainly a well-established standard by the time of the founding and the establishment of our own Constitution in the late 1700s. And that test is pretty much widely applied still in the US today. And the reason that the history and the prevalence of the test are so important is that our lead argument is that Kansas's approach, which is much narrower, violates the due process clause of the Constitution, specifically that it violates substantive due process by offending a deeply rooted and fundamental principle. And again, that's a little bit of a fuzzy standard, but the Supreme Court has said that the essential factors when you're evaluating whether something, a legal idea, is fundamental and deeply rooted in our legal system such that the Constitution requires it, we look at historical practice, and then we look at what the states do today. And so if you look at the history from the Old English cases all the way up through a sort of seminal case in the mid-1800s called McNaughton, which was another English case, and then the early American cases up through the 20th century, the insanity defense has always, again, a point of disagreement, almost always, allowed a defendant to be acquitted even if he committed a crime, meaning that the state can prove beyond a reasonable doubt all of the elements of the crime, provided that the defendant, because of a usually serious mental disease or defect, could not tell the difference between right and wrong with regard to his actions. Over the years, states have tinkered with that formulation. They've put it in different words. They've added or subtracted other components. So, for example, one of the most commonly used formulations asks whether the defendant either couldn't tell the difference between right and wrong or didn't understand what he was doing. So that's the example again, if you were so deluded that you thought that you were squeezing a lemon instead of strangling someone, in a lot of jurisdictions that would establish an insanity defense. And there is a big practical difference between the broader question of whether you can understand right and wrong and the standard that Kansas applies today, which is just whether you could form the intent required to commit the crime. There are a lot of different kinds of mental illness that could distort someone's ability to tell right from wrong, but that would not necessarily prevent them from, say, acting intentionally such that they could commit, for example, murder. And so the effect of Kansas adopting the narrower standard that just asks whether you could form the intent required to commit the crime is to exclude from the insanity defense a lot of the people who it would previously have protected in Kansas and who it would still protect in most of the other states today. And for very similar reasons, we argue that Kansas's approach violates the Eighth Amendment, specifically the ban on cruel and unusual punishment. Again, primarily for historical reasons. If you look at the uniform practice in the colonies around the time of the founding, the firm belief was that the insane, madmen or lunatics as they were usually called, were not subject to any criminal process or prosecution whatsoever.
So I'm just curious, so how does the Kansas rule apply to the lemon example? Would that person be convicted because they intentionally are squeezing?
In that example, that person would not be guilty because that person could not form the intent to harm another human being. So if you don't understand even what you're doing, then you can't form intent, and so you wouldn't be guilty in that example in Kansas.
But if they were mistaken about, they intended to harm a person but were mistaken about who it was, they would still be guilty?
Well, so one example that comes up a lot in the literature is if you saw your neighbor walking up your driveway and you, as a result of a serious delusion, genuinely believed that your neighbor was an enemy spy coming to murder you, and you then shot and killed your neighbor, you would be guilty under the mens rea approach that applies in Kansas and a couple of other states because you intentionally killed another human being, but you may well not be guilty under the historical insanity test because you genuinely believed that what you were doing was not wrongful and not criminal.
So let me ask you one other quick question, then we'll see what Toby has to say. But so what's the breakdown among the states? I mean, Kansas the only state that does this, or what's it look like?
There are 3 other states that have essentially exactly the same standard that Kansas has, Montana, Idaho, and Utah. And then Alaska has essentially the same test. They frame it a little bit differently, but in practice it works the same way. There is a little bit of debate on the margins, but our position is that all 45 of the remaining states have an insanity defense that at least encompasses the right or wrong moral inquiry that we've been talking about.
Okay. Toby, what's going to be your response?
Yeah, so before I get to that, 2 things. First of all, thank you for having me here. And second is Tobias talked about the history, and both his brief and Sarah's brief were outstanding. Since we're talking on Kaler right now, the historical background and the research that he did in his brief, and frankly I think our brief as well, is just like, as a matter of scholarship, is I think terrific. And so history is one thing. Like, I was a history major, but I mean, we're going back to Aristotle, Plato, Justinian law, addressing things in the Old Bailey court, legal philosophers back in the 16, 17, 1800s, tracing it across the ocean. I mean, it's a really complex and well thought out argument, I think, that is a difficult issue. And it does kind of get down, as Tobias says, as to whether or not right versus wrong. And I think that's kind of where we part company, is whether right versus wrong always existed. The Monotone case, it certainly came up, and the early legal thinkers back in England, at least according to the state of Kansas, had kind of always struggled with how they were going to define what it is to be criminal and how much you have to know in order to commit a crime. And if you think about back in the 16, 1700s, there were very few crimes, theft, murder, things like that. And those were all common law type crimes in which there are no legislative gradations as to whether it was an intentional murder, a capital murder, negligent homicide, things like that. So the courts really struggled, and the organized societies really struggled with how they defined what type of person would commit the crime of murder, what type of malady was affecting the individual. And what you see, at least according to the state, is that the thinkers of that time were kind of struggling with how to define what it means to have a criminal intent, what it means to commit a crime, and what, if anything, how do we treat or view the actions of someone whose mental status isn't all there. Because if you look at kind of how it historically came up, you see in the literature referred to as brutes, wild beast, lunatics. I mean, the terminology that you would use for someone who was suffering a mental illness, you'd get banished from society today if you were to talk like that. There was witchcraft, sorcery, things like that. Society just didn't know how to define those things as clear gradations as we do then. And so at least the state of Kansas sees it, is that defining mens rea as criminal intent is kind of part of what the insanity defense and right versus wrong ultimately came into. But at least in our view, we don't see that coming into kind of being concrete until much later into the development of the United States. And the reason that's important is because under the substantive due process test, you do look at the history and tradition as to how that defense came up, as to whether or not, because obviously it's not defined in the Constitution, so it has to be a concept that is deeply rooted in our history and tradition. And I think the state of Kansas would say that governments and organized society have, especially states, have historically taken great pains to both define what criminal law is, as well as setting forth the procedure for how those criminal laws are enforced, what the punishment would be, and things of that nature. And so we see a great deference to state governments to both define the elements of a crime, identify what, if any, defenses would be acceptable for those crimes, and then getting a little to the Eighth Amendment claim, whether or not there is any Eighth Amendment implication with regard to whether mental insanity applies on the culpability side or in the punishment side. So for example, in the state of Kansas, we will move people out of the system if they are incompetent to stand trial, and then if they are competent to stand trial and are convicted, then we will take into consideration their mental status and any mitigating factors with regard to the punishment side. So that's a power that, if you look through the state government in the American experiment, has been pretty consistent, at least according to the state of Kansas. So that's, that's I guess, kind of our argument.
Okay. Well, and I will do my duty. One of the conditions that Department of Justice always puts on me to participate in these programs is that I am to articulate the position of the United States, which has filed a brief in each of these three cases as an amicus. So I'm not arguing, obviously, but the United States is supporting Kansas in all three cases. And the U.S. takes the position in the Kaler case that the court should stay out of this for two primary reasons. One is really a federalism argument, that this has always been the state's territory. There are a variety of approaches. I think the U.S. would suggest it's not necessarily a monolithic view on how to approach insanity versus just a handful of outliers, that even among the 45, there's a lot of variation. And you're welcome to respond to that once I put it on the table, Tobias.
I will.
So the U.S. would say that's always been an area where the states have had a variety of approaches, and the court should stay out of it and leave that to the states. And then the second argument the U.S. makes primarily is it's sort of what I would call a judicial competency, that the courts are not the ones that should be developing a standard, that this really involves moral choices, policy choices, medical choices, scientific knowledge, and that's much better dealt with in the legislative sphere. So whether it's Congress or the state legislatures to develop standards over time. So the U.S. is basically taking the position, although the federal government does not use the Kansas approach, that the court should basically stay out of it and leave the Kansas statute alone. So, but you're quite welcome to respond to the U.S. position.
So actually, I agree with most of what you and Toby just said. In particular, actually, the totally fascinating history in this case. This is the kind of thing that when you're in law school, you think you're going to be doing all the time, and you're usually not. So it was a rare treat to be able to really dive into all of, say, these old English cases. As far as the federalism question, our position is not that the Supreme Court should handcuff all of the states to apply exactly the same test. It's very clear the court has been appropriately deferential to the states in defining substantive criminal liability, in structuring defenses, in allocating burdens, and we, by and large, do not have any quarrel with that. Our view is simply that the states have to meet a sort of minimum threshold that at least encompasses this moral culpability principle that the insanity defense has always focused on. But beyond that, they have a great deal of leeway to shape the defense, to add and subtract different components to it, to put burdens on the defendant, to appropriately prove that he's insane under the standards that the state applies. So obviously there is a federalism concern here, and criminal law has historically been the province of the states and should remain the province of the states. But the Constitution does impose certain minimums. For example, the Constitution requires every criminal prosecution in the United States, whether it's a federal criminal prosecution or a state criminal prosecution, to meet the standard beyond a reasonable doubt. And that's a floor below which the states cannot go, no matter what specific interests they might have in play, and we would argue that the principle here is similar.
Okay. So real quick before we move on to Garcia, I'd like to ask each of you any predictions on who are your friends on the court on this issue? Who do you think is likely to be on your side?
That's a truly tough one, I think, because this is such a sort of big question that implicates a lot of different sort of cross-cutting currents. I suppose there is probably going to be a little bit of the sort of traditional left-right split. I, for one, am very curious to see where Justice Gorsuch is when it comes to the argument, because he's only been on the court so long, and so we've only got so much to go on, but so far he does seem to have a strong sort of libertarian streak when it comes to criminal justice cases, which we're hoping would lead to a favorable vote in our cases. But that is actually something that's very interesting about this issue. The last time the Supreme Court really grappled with the insanity defense was Clark versus Arizona, which was 2006. And so you had neither of the Trump appointees and neither of the Obama appointees. So it really is a different court since then.
Yeah, I don't want to venture a guess as to where it is, but I do think that it'll be interesting to see where the court goes. I think Justice Breyer, I thought you were going to mention the Wolf hypothetical. There was a case out of Idaho a while back that the court looked at this issue from Idaho and decided not to take it, but Justice Breyer wrote a dissent from the denial and mentioned if somebody knows that they're shooting a wolf, they don't commit a crime, but if they believe that the wolf compelled them to shoot a human being in Kansas, that is a crime. That doesn't negate intent. So I would guess that he's probably not in Kansas's favor. But at the same time, like if we lose the folks on the right, like Justice Thomas or Justice Alito, well, then we're done. So I could see this a 7-2 going either way. And I think that's Justice Kavanaugh. We don't know where he's going to be. Justice Gorsuch, and frankly, I think the Chief as well. So I think there's a lot of give in those joints.
Okay. Well, General, you want to give us Kansas' best shot on Garcia?
Well, I think on Garcia, let me do it this way. The court, obviously it's a hot topic. If you look at this as an immigration case, it's not nearly as hot a topic if you look at it as an employment case. I think we look at it generally as an employment case, and the other side looks at it generally as an immigration case. So, perhaps the argument will, to some extent, reflect, those different framings. If you look at it from the immigration side, the cases that, interpret the preemptive scope of that provision of the 1986 statute, you have the first one out of Arizona, it was Chamber of Commerce versus Whiting. You have the second one out of Arizona, it was Arizona versus United States. Then you have some lower court cases that haven't made it all the way up. One out of Arizona, Puente, Arizona, that went to the Ninth Circuit, and one out of South Carolina. As we look at those, in all of the relevant parts of those cases, some of them have nothing to do with what we're arguing about here, but in all of the relevant parts, you had a state that there was evidence in the record suggesting it set out to do something that was, maybe colloquially described as enforce federal immigration law, as a function of state law. You had Arizona passing, I think Senate Bill 1070 was the reference, which was expressly designed to, under state law, criminalize conduct that was already forbidden under federal law. The same in the South Carolina case. In the Puente, Arizona case, you have the same thing. It's the closest in the sense it's about an identity theft statute, but we would argue it's not close in the sense that you had an Arizona identity theft statute that was enacted expressly for the purpose of focusing on people who were not in the country lawfully and were committing identity theft to try to go get a job. In our case, none of that is present. There's a slight disagreement factually on that, but I think even the other side would agree it really is a slight disagreement. The Kansas statute is a generally applicable identity theft statute. There's nothing in the record, because it wasn't the case, that it was not enacted by the legislature with anything related to immigration or unlawfully present employment in mind. It's our general purpose ID theft statute. There's nothing suggesting, this is where we might have a little factual disagreement, there's nothing, we think, suggesting that it was applied, that the way it was applied in Johnson County was motivated by a desire to use it to go after folks who are not in the country lawfully. Now, the other side would push back on that and suggest, well, but most of the cases that reach the appellate courts in Kansas are out of Johnson County and are in fact involving folks who are in the country unlawfully. And that's true as far as it goes, but the rest of the story on that is that most of the identity theft cases in Kansas are out of Johnson County, because Johnson County is very large. Johnson County is relatively affluent, and so there is a greater incentive, if you will, to steal somebody's identity for some type of financial gain. And the Johnson County District Attorney's Office, unlike every other prosecutor's office in the state except maybe Sedgwick County, has a white-collar crime unit that is well-funded and goes after identity theft and related fraud. So it shouldn't be surprising that they have more cases. Likewise, the fact that most of them that wind up on appeal happen to be in this context also isn't particularly surprising, because the basis of the appeal is the intersection of federal immigration law with the application of the ID theft law. If you don't have that fact present, generally you don't see these cases go up because there's really not a whole lot to appeal. At least that's been true in Kansas. So I think we're going to wind up maybe to some extent arguing about that, but our best shot, to get back to your question, Steve, will just be to portray this for what we think it was, which was a prosecutor doing their job in a way there's no indication they set out to try to disproportionately affect or enforce federal law. And there is no indication, we think, in the enactment of the federal law that Congress intended to preempt states from doing their traditional police power enforcements in that sort of context.
Either the defense lawyers want to comment on that one. I can do the U.S. position again, but you want to comment on it?
I don't have any views on that one.
Yeah.
Okay. Yeah, I mean, and the question obviously is, I think, whether you try to turn that into, as you said, General, more of an immigration case. And the argument is about preemption. I did want to comment on these three cases. So we do have very different provisions of the Constitution at issue in each of these three cases. So in the Kaler case, you're really talking about 14th Amendment due process and 8th Amendment. In this case, we're actually talking about Article 6 in the Supremacy Clause, whether federal law prevents state law from being operative. And then in our final case, we're talking about the 4th Amendment, unreasonable searches and seizure. The U.S. is actually supporting Kansas in the Garcia case as well. That may be particularly significant in the Garcia case, because when you're arguing a preemption case and you're saying federal law preempts state law, in other words, makes state law inoperative because it gets in the way of federal law, it's usually pretty helpful to have the federal government saying, no, Kansas is not in our way. Their law can operate. We're not concerned about it. And so the federal government has taken the position that neither the words of the statute preempt the application of the identity theft laws, Kansas laws, so there's no express preemption, nor is there field or conflict preemption under the 1986 immigration statute. So I don't know, that may well prove to be very helpful in this case. Any predictions on your votes? Who's your friends in this case?
Well, I hope the justices in the majority are our friends, but we'll see where it ends up.
Well put.
I'll leave it at that, other than to say this. If you go back and look how the remaining justices that are still on the court but were there in the Whiting case and in Arizona, you know, it's not entirely the traditional conservative liberal split on those cases, and so it is more interesting than that. And because of the new justices since then, I think it's you know, there's more of a blank slate than there might otherwise be.
Okay. All right. Well, let's tackle Kansas versus Glover, and I guess, Tobe, since you on the losing end of that one, I'll let you give your best shot first, and then we'll let Sarah shoot you down.
Is that your prediction? I like it.
So I think our best, and I'll preview what I think Sarah's best argument is too, because I think they go hand in hand. I think our best argument is the common sense notion that the registered owner is frequently, certainly not always, but frequently the driver, and that the officer was reasonable in making the assertion that the registered owner was likely the driver. We go through a whole host of scenarios in which the intrusion is limited. I think it was 16 state Supreme Courts and 4 circuit courts of appeals have said that you may all,
According to you,
disagree, right? So, you know, so I think all of the courts that have looked at this before Kansas had said that it was reasonable for an officer to at least investigate whether or not the registered owner is the driver. There's a scenario in which, you know, you would pull up to the car and if it were Tobias as the registered owner, you wouldn't know necessarily whether if it were Toby, if that were a boy or a girl. I mean, there are things like that. I think the reasonableness of the officer's actions is a fairly common sense one. The standard for reasonable suspicion is quite low. In historical cases that the court has looked at, that standard has been very, very low. Probably the closest one is the driving while under the influence. There was just limited facts in that case. Sarah has identified in her brief several cases in which the factual pattern that the officers had to kind of put together was a lot more complex and what I would call more complex crimes. You know, I think Sarah's best argument and our biggest hurdle is maybe something that Steve first taught me, is that the rule of the Fourth Amendment is if you can imagine it happening to you, it violates the Fourth Amendment. And I think that's a pretty strong reaction, because as the trial judge said kind of colloquially, like, I have 3 cars and I don't want my daughter stopped for driving the car. And I think that's a base human interaction and certainly a hurdle that we'll have to overcome. My suggestion would be that the limited interaction that the officers would have satisfies reasonable suspicion. But I do think that there is that internal dig of whether you can overcome that. So that's
Right, or if it's whether you can imagine your teenage daughter
Right.
having it
That's
happen
right.
to her, right? And I'm glad you picked up on that. We tried to push those buttons a little bit.
Oh, really?
Yeah. And I just want to preface what I'm going to say by saying that Toby has been a lovely opposing counsel, and it's really been a pleasure. And he obviously is handling 3 cases, has had a lot of work, and has been just nothing but wonderful to work against/with, and has produced some great briefs. So you guys are in good hands. And I'm sorry, every time I turn my head, I get microphone noise, so I apologize for that. I'm trying to just sit really stiffly, but it's not because I'm uncomfortable. So, you know, the Fourth Amendment, the Supreme Court's approach to the reasonable suspicion standard, Toby's right that it's generally viewed as a low standard, but they have been extremely resistant to adopting bright line rules in this context. And so anytime someone has come to them and said, you should say that anytime an officer knows X and X alone, it equals reasonable suspicion. And they have always said, you know, it's just not the way it works. You just really have to look at the totality of the circumstances. You have to hear from the officer what his experience is, what his training is. You know, so there have been cases where someone was stopped for being in a high crime area, or where people who looked like they were of Mexican descent were stopped near the border because the officer wanted to investigate whether they were here legally or not. And the court has said in those cases, it's just not enough that that there's just the fact that this person, based on where he is or what she looks like and where she is more likely to have committed the crime you're interested in. That's not enough. You have to have some kind of suspicion that's based on something, they call it particularized to the person. So you have to have there has to be something about what the person is doing, what you observe, that makes you think that there's a crime being committed. And it doesn't have to be something that every human being would think, oh, I see that thing happening and maybe that is a crime. Because officers have specialized training, they have experience. And so if the officer in this case had come into the court and said, look, I know this guy. I've pulled him over before driving on a suspended license. Like, I had reason to believe he was doing it again. Or I've pulled over 100 cars where the registered owner had a suspended or revoked license, and in 98 of those cases, that was the person driving the car. You know, if you had something like that that sort of showed the basis for the officer's suspicion, that would probably be enough. If the officer knew something about the demographics of the driver and pulled up next to the car, where this happened, there's a four-way stoplights, multiple lanes of traffic in every direction. It isn't like a, one-lane highway in the rain in the middle of the night or anything. It would not have been difficult for the officer to sort of come up and look and see, does this person look like they could be the person who's the registered owner of the car? There are a lot of ways that an officer can get a little bit more information that would confirm the initial suspicion that's not based on anything that the driver's doing, it's just based on who the registered owner of the car is. And so Toby leans on this sort of common sense notion, and it is an appealing common sense notion at first blush that it's likely enough that the registered owner of a car is driving the car. But then you have to add without a valid license, right? So it becomes, in my mind, significantly less likely that the registered owner of a car is driving the car if they don't have permission to drive the car, if it's illegal to do so. I think it actually becomes more likely that someone else is driving that car, because people will get their licenses suspended or revoked. They still need to get to work, they still have to get to the grocery store, they still want to go to church, their kids have to go to school, so someone's got to drive the car, and it becomes a lot more likely that it's someone else and not the owner who's in that car. And Toby makes this argument about, well, the intrusion isn't very great, and the United States leans heavily on that in its brief. But it's not as light an intrusion, I think, as they would have the court believe. The stop happens, the officer gets out, the officer has to interact, even if the officer sees, oh, it's a woman, the registered owner is a man, so I know that's not that person, my suspicion is negated. The person doesn't just get to drive away, the officer has to interact with that person and say, never mind. The Supreme Court has said the officer can order that person to get out of the car without that being an additional intrusion. The officer can ask for identification. The officer can sort of observe the inside of the car, can ask for permission for consent to search the car, to question the person. If the driver appears nervous, the court has often found that to be a reason for further inquiry or further search. A teenage girl who's being pulled over because her father has a suspended license, but she hasn't done anything wrong, of course she's going to appear nervous. So it is potentially a lot more intrusive than I think people, than the governments have argued in this case. It also is likely, it's a burden that's likely to fall on some communities much more heavily than other communities. In many states, the majority of license suspensions are not based on traffic stops, not based on traffic safety violations. They're based on inability to pay fines or to pay child support or things like that. So they're based on poverty. And so these kinds of stops are much more likely to happen in communities where there's already a heightened degree of tension between the police and the community, and those kinds of stops can have much higher stakes, much more severe consequences.
Okay, so you referenced the United States, so I'll say
Yes.
the United States, again, supports Kansas and takes the position that this should be reasonable suspicion. If you run the plate and it says the registered owner has a revoked license, you should be able to have reasonable suspicion the driver is the registered owner. And they do cite something which I did not check, and you may know better than me, but I thought they cited something in the brief that suggested perhaps as many as 75% of people with revoked licenses drive anyway. So
drive at some point, but not necessarily as often as they used to. Yes.
So there may be some statistical arguments. They also suggested the alternatives of, trying to see who's actually driving could be dangerous to officers if they have to try to somehow come up beside. Maybe it's two-lane road. They can't even pull up beside to where they can see who the driver is, whether it's male, female, young, old. That sort of thing is impractical and unsafe in and of itself. But in any event, the U.S. is supporting Kansas that it should be reasonable suspicion. And you're welcome to respond to any U.S. arguments if you want.
Yeah, no, I mean, our basic take is, well, if it is dangerous to get information about who's driving the car, then that might, then you might be able to make the stop. But and if there is statistical evidence to suggest that people with revoked or suspended licenses continue to drive as often as before, then that's evidence you could give to the trial court. None of that was presented to the trial court in this case. Our view isn't that it should be particularly difficult to make this kind of stop, but that you need to do the minimal amount of work that is required, and it just wasn't done in this case.
Okay, so predictions, who's with you or against you?
So, it's hard to know. I mean, it's similar to what everyone else has been saying. The new guys are a little bit of a question mark. I think traditionally in the Supreme Court, there was sort of a right-left breakdown in criminal cases, right, where the lefties went with the defendants and the righties went with the government. That has changed in the last decade, I'd say. There has been a growing kind of skepticism of the government prosecutors by the kind of the center right of the court. So the Chief Justice, for example, I think has, particularly with the federal government, has this view that the government is just overcharging criminal matters. That hasn't really trickled down into the Fourth Amendment context, but the new guys, Chief Justice Gorsuch and Justice Kavanaugh, they do sort of have libertarian streaks, particularly Justice Gorsuch. I would like to say we're going to hope for his vote, except that when he was on the 10th Circuit, he wrote an opinion basically adopting the rule that Toby wants the court to adopt. So maybe he will rethink it after he reads my brief. We're hoping. But we did get some interesting amicus support for our side from kind of conservative libertarian voices, the Cato Institute and Rutherford Institute. There's also this sort of privacy, this kind of technological privacy angle to the case where, in this case, the officer ran the plate manually, but many jurisdictions do have these automatic ALPRs, automatic license plate readers, that can automatically scan, thousands and thousands of license plates automatically and spit back information. Oh, the registered owner, has a suspended license, and so that sort of increases dramatically the chances that people will be pulled over if they're driving their parent's car and the parent has a suspended license. And I do think some of the more conservative members of the court have kind of technological heebie-jeebies in the privacy area, and so, and we got some amicus support on that angle too. So, we're hopeful, but.
Yeah, so I was going to mention now Justice Gorsuch. I think it's one thing to apply the law that is given to you when you're sitting on the circuit court, but it's quite another when you're sitting in the driver's seat. And so I think it'll be interesting to see whether Justice Gorsuch's view is the same. We hope it is, because that was a big part of our cert petition on our briefs. And you mentioned the amicus brief. I should have mentioned this earlier. So part of what I didn't appreciate about the job is the role of an amicus brief. And Sarah's brief was outstanding, as you would imagine, but just in 2 or 3 parts, she had maybe 2 paragraphs that talked about a theme, ALPRs, for example, 2 or 3 parts that talked about fines in small communities. And so she layered those with amicus briefs that hit on those points and then submitted 6,000 or 7,000 words on those points. So I wanted to commend you for that. It's just a very well done thing, so it grabs her themes from her brief and just does a really nice job with it. I think it'll be interesting to see how Justice Kavanaugh handles this case, and frankly, the Chief, I think, will be an interesting vote as well, because the court has really struggled.
He has a teenage daughter. But he would never have a suspended license, so, yeah.
Although, didn't he mention a few terms ago about driving over the speed limit outside the statute of limitations?
Yeah.
So, I think that those are interesting things, and I heard at one point somebody said never give up on any votes, no matter how difficult it is, and I think that's the kind of the theme of our case. I think Justice Sotomayor has written some dissents that talked about the parade of horribles that were in Sarah's brief about what can happen, but we'd still take her vote, and we'd like a majority.
Yeah, I don't think you're going to get her vote, and I don't think we'll get Alito's vote. But I think,
right,
yeah, I think Kagan could be in play for you. She's a
right.
very common sense, practical, thinker, and
and so that's part of the thing is you write knowing that, you know, there may be one that you may not get, but you still have to get to 5, so.
Okay, so I think we'll take some questions in just a few minutes, so that's a warning to be thinking of your questions. But I have kind of a final round of questions for you, and this is a little different. I think the audience might be interested. So I thought, Tobias, I would ask you, since you worked on the cert petition in Kaler, how do you approach trying to get the court to pay attention to 1 out of 7, 8, 9,000 petitions? You know, how do you try to get them interested in the Kaler case and to take it? What do you focus on? What did you do in that petition?
Sure. So there's a traditional formula to writing a cert petition where you try to establish 3 things. One, that the lower courts are divided on the question. A huge part of the Supreme Court's job is resolving conflicts and disagreements among the lower state and federal courts. And I think one of the things we were able to do effectively in the Kaler cert petition was demonstrate that there was real disagreement on this. The Supreme Courts of each of the states that have adopted the approach that Kansas has adopted have upheld that approach, except the Nevada Supreme Court, which struck it down, basically on the same grounds that we're arguing in this case. And there are also a number of state Supreme Courts over the sort of 80 or so previous years that have all held, for one reason or another, in one context or another, that the insanity defense is a fundamental principle of due process. So we were able to point to a pretty clear split on this, and that is always a very important part of a cert petition. I think we also did have one advantage here, which is that this is the kind of question that you can state in a single sentence that sounds really cool to most people, and certainly to most Supreme Court lawyers. The first page of a cert petition that goes to the Supreme Court, it's the very first thing they see, is the question presented, which is the legal issue you're asking them to resolve. And very often, especially in complicated cases that involve federal regulatory regimes, there's about a half a page of just background explanation before you actually get to what the real question is. What's the beef here? Ours was one single sentence, which was basically, do the 8th and 14th Amendments allow a state to abolish the insanity defense? And that grabs your attention right off the bat. In fact, a lot of the people that I talked to about this case when we were first getting started on it, when I first mentioned this to them, said, wait, really, that's an open question? And I hope that the clerk who read this the first time and then the justices, when they read it, had the same reaction, because that's what we were going for. And so that goes to one of the other factors that you have to show, which is that the question is important. And there are a lot of different ways you can come at that. You can show that it's practically important because it affects a lot of people, or you can just try to show that it's the kind of sort of fundamental bedrock legal question that the Supreme Court should be concerned about. And then the last thing you want to try to show, if you're asking the Supreme Court to take a case, is that the decision that you're attacking is wrong. And that's where you sort of preview your arguments on the merits of the legal question. Although a lot of the time, that is not the most important thing you're doing in the cert petition, because you're trying to do a lot of other work, and you're going to save the real heart of your merits arguments for the merits briefing if you are lucky to get that far. And then one other thing, which we actually did not have in this case, but that often is very helpful, and Toby touched on this, is amicus briefs. One way to get a cert petition to really stand out of the big old stack that they get is to have other parties submitting a brief in support of your petition to say, this is an important issue, this really matters, and you should pay close attention to it.
Okay, and General and Toby, I'm going to ask each of you to talk a little bit about, and I'm really curious to hear Toby's answer, but how you prepare for these oral arguments. Well, what do you do to get ready for, because I've been with you preparing.
I was going to say, up until now, I've pretty much asked you what I need to do. Now I ask Toby.
No, but tell them a little bit about what it takes to prepare. So.
We're not, Steve more than Toby or I, but generally speaking, we're not frequent practitioners in front of the court. And Supreme Court advocacy is different from other appellate court advocacy. It's not perhaps different in nature from federal circuit advocacy, but it's different. It's different in degree, and I suppose in a sense it's different in nature as well. It's always more policy-based, even if it's not a policy-based argument, because to Toby's point, when you're in the driver's seat, you can decide which way to steer. And so it's different from what we do day to day, and it's different from what I do day to day. And so it takes me a lot of time, in prepping, just because I don't do this that frequently. So I just go back to basics. I mean, you want to know your record, you want to know the pertinent law, you want to have time to think about it, you want to play out how you think the law either supports or doesn't support, or the record supports or doesn't support what you think the answer is. You want to figure out where your strengths and weaknesses are. You want to have people attack your case so that they can help you figure out where your strengths and weaknesses are. We'll moot these multiple times, and we'll moot them with a variety of different perspectives, some academics, some Kansas practitioners, a variety of Supreme Court practitioners from different perspectives. And we'll do that because the goal is by the time we get to the oral argument, we've heard it all. We may or may not have the right answer, but our goal, which we may or may not succeed in meeting, is that we aren't surprised with anything that any of the 9 ask us. So.
And you might just, for the non-lawyers, explain what a moot is. What do you do in a moot?
Right, so it's like law school, kind of, sort of. You know, a moot court is a mock court. You get folks who play the roles of the justices. Hopefully they have different vantage points on what the case is about, or what the advocacy is about, or what the nature of Supreme Court advocacy is about. Again, back to the idea, sometimes academics, sometimes practitioners, sometimes none of the above, because occasionally we'll discover that our Kansas practitioners who have never appeared in front of the court ask the most helpful questions, because they're not thinking in these strategic terms. They're just thinking, what's this case really about? So you want to blend all of that together. And then, but yeah, I mean, a moot's, it's that. You go into the role, you argue the case, you get the questions, and then hopefully some helpful feedback afterwards to get you better prepared.
So Tobe, October 7th is your debut, so how are you going to be prepared?
So I'll answer that in an odd way. I'm the least qualified on this panel to answer that question. And I remember when I saw Sarah came into this case, I was like, I don't know who Sarah is. So I Googled her and I was like, oh, well, she's only argued 21 cases. And I've argued 0. So how I'm doing it, I guess, is unlike a lot of folks on this panel, is my brain doesn't work very quickly. And so I don't have any choice other than to work as hard as I can. And so go to the record, go to rereading the articles from about the 1600s, rereading the cases, writing an outline, erasing it, rewriting it, practicing it in my head. You know, and so that's October 7th. I think I've probably been working on that argument, getting ready for it for 6 weeks, you know, just kind of from here to there. That's what I'll do all weekend and every weekend until October 7th, and then we'll get the boss ready for October 16th, and then get ready for November 4th. So I don't know. I'm going to do the same moves.
And vacation, right?
What do you mean vacation?
So yeah, I don't know what to do, and I'm kind of looking for answers up here. So if you've got any advice, anybody up here, I'd take it.
I'll sit in on some of your moots. So.
Beat me over the head.
So Sarah, would you talk a little bit about, Toby complimented your use of amicus, and just kind of, you've had a lot of experience with that. Explain kind of what amicus are, how you acquire them, recruit them, find them, or they find you,
Yeah.
how that all works, and how they fit with your work in this case.
So the term is amicus curiae, which is a Latin term meaning friend of the court. And basically it's someone who's not a party to the case, so not the plaintiff or the defendant or intervener or whatever, but someone who has an interest in the legal question that's presented in the case. And so the United States is amicus in all 3 of our cases. They are not a party to the case, but they, as the largest law enforcement entity in the country, have an interest in how these criminal cases are decided. And so it's been an interesting learning experience for me, because I've been in private practice for 2 years. I was a DOJ lawyer for 17 years before that, 8 years in the Solicitor General's office, which does the Supreme Court litigation for the whole United States. And the SG's office does not recruit amici in its cases. And so this has been, kind of a new thing for me, and I luckily have wonderful colleagues who've sort of given me some guidance. But the basic thought, and Toby kind of previewed this, is that if there are points in the brief that are helpful to you, but are kind of not the central theme of the case, not the central legal argument, but that you don't really have enough words to address. There's our brief came in just under the word limit, and there was a lot more to be said about some of these things. Then you look for people who can speak credibly to those issues. And so we had a group talking about, it was led by the Fines and Fees Center, but joined by Cato Institute and Southern Poverty Law Center and some other folks, talking about how license suspensions are largely based on inability to pay fines, and talking about just the sheer number, millions and millions of people in the country who have lost their licenses on that basis. We had the EPIC, which is the Electronic Privacy Information something. I can't remember what the C stands for, but they came in and filed a brief about the ALPRs, about sort of the extent to which kind of our information can be gathered automatically through electronic means. We had a law professor come in and file a brief talking about sort of the Fourth Amendment kind of more theoretically. We had NACDL, which is the National Association of Criminal Defense Lawyers. They may have filed in all of these cases, I'm not sure. But they often come in and just sort of speak, they are repeat players in these criminal cases and just sort of give the broader perspective on criminal law issues. And so it was a combination of some of those people reached out to me and I reached out to some of those people. And in trying to sort of brainstorm who to reach out, and I reached out to other people who ended up not filing briefs. In trying to brainstorm who to reach out to, I kind of looked at other cases that, recent cases in the last 5 years in the Supreme Court that had some synergy with this case. So there have been some cases about electronic surveillance, and I sort of looked at what groups had filed in those cases and made some inquiries. And then, like I said, some other people reached out to me.
Okay. Well, I think at this point we'll open the floor to any questions on any of the cases or anything Supreme Court related you might want to ask. We've got one up here.
Thank you. Steve and Toby in general, we know how you became involved in these cases. I wonder if Sarah and Tobias could tell us how they became involved. Coming from such prestigious Washington, D.C. law firms, how did you become involved in cases in Kansas?
Please.
So it was mentioned in my introduction that I am an instructor in the Harvard Law School Supreme Court Litigation Clinic. And so in that clinic, we bring students to DC for the month of January, and we have them in teams, and we, with them, write briefs that are filed in the Supreme Court. And so in preparation for that class, we need to come up with projects for them, and they're real briefs, with real clients, but they're generally pro bono or public interest topics because the students' labor is free. And so I just was sort of keeping an eye on the Supreme Court docket, and I saw the cert petition that Toby filed, and I reached out to the existing counsel. I don't know if my co-counsel is in the room or not. He said he might come, but Skip Griffey, and just said, hey, I saw this petition was filed. It alleges a split. Seems like a plausible split. If you would like help, I would love to give you help for free in conjunction with the clinic, but I would supervise everything and we would keep you involved. And so that's how we did it, and it was a great experience. It was my first time teaching the clinic, but I was saying at our dinner before this that it was really a wonderful experience. That law students are so, I don't mean this in a condescending way, so bright-eyed and enthusiastic, and I am not very cynical about the practice of law, but even for me it was just like really lovely to get to work with them, and they were really thrilled to work on the case, and then when the case was granted, Skip kindly decided to keep me on, and so we've worked together on it, and it's been a real pleasure.
My answer is actually very similar. My law firm, Sidley Austin, has a long-standing relationship with the Supreme Court Clinic at Northwestern Law School, which is very much, as Sarah describes, a fantastic opportunity for law students to actually work hands-on on real briefs in Supreme Court cases. And that is how a lot of our pro bono Supreme Court work comes into the firm. And so I think in our case, the communication went the other way, but it was because we had previously worked with the capital appellate defenders here in Kansas in other cases a couple years ago. And as I understand it, they reached out for help with the petition when it came up.
Other questions?
Thank you all for this very interesting discussion. I want to refer to the Glover case, and it was alluded to, but I'm still not clear what the reason was for the officer running the tag.
Well, I think it's stipulated that there was no reason, right? And correct me if that's not your understanding, that he just ran it because he wanted to run it. Exactly, that's a great reaction. Outrageous, right? It's actually, there's nothing wrong with that. Under the law, they're allowed, your license plate is a publicly displayed bit of information, officers can run it, but our view, of course, is that you shouldn't they should have to observe something about you before they can stop you, because the Fourth Amendment right is a personal right. It doesn't belong to your license plate. So.
And just as a follow-up to that, a little different take. So, it is not uncommon for officers to do that, and you don't know that at all. And it provides an important law enforcement interest. The Oklahoma City bombing, as you might remember, Timothy McVeigh was stopped because of a license plate violation. There was a serial killer out in, I believe it was New Jersey, that was identified on a license plate violation. There are a whole host of U.S. Supreme Court cases that significant crimes came up because a license plate indicated that the person who was the registered owner was perhaps in the car, and that led to a bunch of different things. So license plate...
In the car, not driving.
License plates, historically, it goes back to, I think I went and looked at this, it didn't make the brief, but I think it's the early 1900s or late 1800s, and it literally was designed so that the government can identify who owns the vehicle, who's paying the taxes, whether the taxes have been paid. And so the lawful reason to have license plate is literally to figure out who owns it and who's responsible for the vehicle. So.
But I like your reaction.
Excuse me.
So Sarah, I wanted to thank you for commenting about how wonderful it's been working with your opposing counsel in this case. We have a lot of law students in the hall today, and I'm a law professor, and one of the things that I always stress is collegiality and how important it is to work with opposing counsel. It makes your job so much more pleasant, and the two of you, just your banter back and forth, I think has exhibited that. Could you just expound a little bit about how important that is to, of course, do your job and defend your client and those interests, but how important it is to work with counsel who is just nice and collegial and professional and all those things?
Yeah, I mean, I think I like to approach all my relationships with opposing counsel with sort of an assumption of good faith, that I am trying to represent my client in the best way I can, and he or she is trying to do the same. And you know, I think there's a different tone sometimes in these relationships when you're talking about appellate lawyers versus trial lawyers. You know, trial lawyers are just there's a lot more interaction and a lot more things you have to fight about or work out together. And so I think that I've never been a trial lawyer, but that gives rise to a lot more opportunity for conflict. I've always been an appellate lawyer in the courts of appeals or the Supreme Court. And there, like, you kind of have to work out the schedule, the contents of the appendix. But, you know, then you're kind of like just doing your thing and they're doing their thing. And I have just learned through, you know, I've been an appellate lawyer for 20 years and just learned that it's just better for everyone if you can get along. And, you know, I've had hundreds of opposing counsel in Supreme Court cases in the Solicitor General's office, and there are only two I didn't like, and I remember them, you know, because they were just jerks and, like, we couldn't work things out. And, you know, especially, I mean, Toby had 3 cases, right? There were like 2.5 people in your office. You do the job part-time, right? And so initially when we were setting up the schedule, I was like, why don't you tell me what will work for you? And let's try to make that happen, because I just can empathize that that's a difficult situation. I mean, it's a wonderful / difficult situation to be in. It's intellectually challenging and amazing, but just trying to set it up so that you can get all your work done in a effective way is a challenge logistically. And so I think we were really able to, it was really easy to kind of work out how that was going to function. And he was very respectful of my family vacations and all that kind of stuff. And it's just, it just makes it a lot more pleasant, you know.
Yeah, and so, thank you. There's another component. So, like, I work in a public office for this gentleman down, and so what I do reflects upon him. He set a standard, and if I'm a jerk to Sarah, she's going to remember me as the third jerk she knows. But also, it's going to get back to the boss, and probably through somebody that's his constituent, and then he's got to answer for me. And so, you know, I have a professional obligation, but I also have an employee relationship that I need to maintain. I have to. He's my client as well, and so I think that's important. And, you know, I think it's the lawyers in my office. There are 6 or 7 of us that were working on this, and it was a challenge. I'd mentioned to somebody today I'd like to know what it'd be like to have one Supreme Court case. I think that'd be awesome. It was a challenge to get everybody's schedule. You probably don't remember back in May, you were across the ocean. Coordinating the lawyers in my office with the boss's schedule, with everybody's schedule. I mean, everybody has to edit the briefs, and that's just on our side. And then we've got a joint appendix to worry about. In the Garcia case, the lawyer switched firms. Like I saw it on the news first, and I was like, that can't be possibly right. Surely he's not. Man, he's a much better lawyer than I am. Sure enough, a couple weeks before his deadline, he's like, hey, I need some time. And as Sarah mentioned, we had a schedule that I'd hashed out with Jeff at Sidley, this lawyer, and Sarah, so that everything was sequenced, so that we had a team of lawyers. 4 lawyers were working on this case, 4 on this one, 4 on this one, and there was a core group of us on all 3 of them. And literally, it was like I have an Excel spreadsheet as to what we were doing. And so this guy calls me, this guy who I don't know, right? He calls me, he's like, hey, I'm in a bind, and he tells me, change this law firm. I was like, yeah, I thought it was crazy you were leaving, but okay, I'd love to help you, but here's my problem is I've got all these schedules that I've got to go with. And I know that Sarah's brief, who we're going to have to move, is going to go over her family vacation, because for whatever reason, I remembered you mentioned your family vacation, and I said, I'd love to help you out, but it's going to hurt her vacation, and it doesn't help me out any. So we got her on the phone, and so she was able to get her brief done before she left and then file it after. And so that level of collegiality, I have been in the trenches as a litigator, doesn't exist anywhere else. And like, I'm an outsider to these guys who do the Supreme Court practice all the time, and they've treated me like, like I'm one of their long lost friends. And so I think that's, for me at least, like it restores what you had hoped for in law school, because it isn't like that. And everybody that I've worked with has been fantastic. So.
And I will say, notwithstanding that the Supreme Court bar itself is very collegial, I mean, Toby himself has been incredibly collegial and welcoming. This is definitely the only time this has ever happened for me with an opposing counsel. When he found out I was coming to this event, he called me, and obviously has a lot to do, but spent 15 minutes talking to me about what's in Lawrence, what restaurant I should go to, if I had a free afternoon, go running down by the river, check out the Allen Fieldhouse. And it was tremendously warm and welcoming and kind, and didn't have to do it, but well, I appreciate it very much.
Good evening. My name is David Trevino. I'm a local attorney here in Lawrence. I practice immigration law. So my question is regarding the Garcia case. And the question is to you, Attorney General. Obviously, this case has gone all the way to the Supreme Court. Wouldn't it have just been more simple just to perhaps have the state dismiss the case and just refer the case to the feds, to the U.S. Attorney's Office, if it's just, as the defense asserts, a federal issue?
Well, it only would have been simpler to do that if the defense is correct on what this case is. The 3 individuals who were convicted in these 3 consolidated cases, one was convicted of identity theft, 2 counts of identity theft, I think. No, it was just 1 with Garcia, wasn't it? 1 count of identity theft on his W-4 tax withholding form. Mr. Morales was convicted of identity theft with respect to using the false number on his W-4 tax form and his K-4 tax form, which is a state document, not a federal document, so I'm not sure there'd be federal jurisdiction on that crime. He was also convicted of making false information for the same false statements on the same documents. And then the final one was 2 counts of identity theft on the W-4s. So, I mean, our position is that, notwithstanding the fact that all of those tax documents were submitted at the same time and for the purpose of getting a job, they have nothing to do with immigration law. They're submitted by citizens, non-citizens, lawful aliens, non-lawfully present aliens. Their purpose has nothing to do with lawful presence or immigration. It's to comply with the tax laws. And while they do have to be submitted or you don't get the job, that really is irrelevant to whether it's an immigration matter or not. So to your point, I mean, if the defense turns out to be correct, that these really are immigration cases, then I see your point. If, on the other hand, we're correct, and they really are much more run-of-the-mill state identity theft or false writing cases, including for crimes committed on state of Kansas, not federal documents, then no, I don't think it would make much sense to ask the U.S. Attorney to take them. Although we could ask him, he's right here.
And he'd be recused from those cases, because I wrote the cert petition in that case when I was still SG, so, yes.
Thank you all for being here and this opportunity. I was wondering for the insanity defense, how do you go about proving that in the moment a person perceived that it was a lemon versus a human? And I guess tied to that, how do you prohibit someone from believing they were strangling a human, but then in the court saying, I thought it was a lemon?
Well, so this is exactly the kind of question which I'm sure makes Toby very happy, because one of the biggest issues with the insanity defense that judges and scholars and medical professionals have struggled with since the beginning is, how do you actually prove that someone was insane, whatever definition of insanity that you're using? And the short answer is you have a psychiatrist examine the defendant, often over the course of many months, and you have them offer their best professional understanding of what the defendant believed and what their motivations were and what they thought. But that is not an exact science, and so of course there are going to be cases where people are going to disagree. Our view is that the Kansas law changed as part of a backlash against the acquittal of John Hinckley for trying to assassinate President Reagan. And he was acquitted because he was deemed insane by the people actually involved in that case. But a lot of people in the country felt like that was the wrong answer. So there always are going to be cases where people disagree about the appropriate result and where it's going to be debatable exactly what was going on inside somebody's mind. Although I will say that is always going to be true whenever you're talking about a case that touches on mental illness, whatever the legal standard is. And for that matter is often true in cases that don't have anything to do with mental illness, if it's just a question of what somebody's intent or purpose was.
Yeah, I think we have time for one more question. I think does the cameraman want to ask a question?
Thank you. I guess this is mainly for the Attorney General, Mr. Schmidt, but if anyone else has information or interest in it, I was wondering whether you could answer an explanatory, maybe looking back to the current moment, and anticipatory, or is this the kind of case that could go to the Supreme Court? The Esther Kuntz case, the Mennonite math teacher who, because of her religious conscience and commitment to supporting Palestinian rights, refused to sign a document saying she wasn't boycotting Israel. So I saw that you had joined a group of attorneys generals from a handful of states in an amicus brief in support of Arizona, similar kind of line of law. And then just in terms of what we read to start out in terms of the principles of our country, it may be that more and more people, to protect the common defense or protect liberty in terms of Israeli spying, Jeffrey Epstein has been reported to have been working with Israeli military intelligence. More and more businesses, bigger government organizations, and people might want to do this kind of thing. So what do you anticipate in terms of Kansas law, in terms of this question of anti-boycott, divestment, sanction, and where do you think this is going nationally?
Thank you. Question.
Right. So, I got to spend 10 years in the state Senate before I got to do this job, and had 10 good years of rollicking policy making, and made an affirmative decision when I got to start doing this job as the state's attorney that I would sort of cabin my policy advocacy to things that I think are squarely within the ambit of the Attorney General, criminal law and that sort of thing. And that approach, I think, really has served the office well. I hope it's served me well. And I think that sort of squarely addresses your point. Kansas has a law enacted by our legislature that discourages, it's an anti-BDS law, it discourages boycotts of Israel. One of the ways it does that is to create limitations on state contracting with individuals who participate in BDS activities. The statute was enacted, by the way, after I was there, so I've never cast a vote on it one way or the other. But we've defended it when it's been challenged. It was challenged by Ms. Kuntz, as you mentioned. Ultimately, that case was dismissed. We defended the state, defended the statute in it. The case was dismissed after the legislature made some modifications to the statute that mooted that case out. But because we do have a law, I think Kansas has an interest, and certainly as Attorney General, I have a role in making sure that we defend the authority of our legislature to make that decision if they choose to, which is why we participated in, as an amicus in some other states' litigation where the validity of BDS, anti-BDS statutes are being challenged.
Thank you very much. I want to thank all of you for coming this evening. And when I told you we were having an outstanding panel, you heard for yourself. We did. And we want to thank our guests because they come because they want to be able to share this information with us. And because, as you heard our moderator, Steve McAllister, say, this is a unique situation for us to have 3 cases before the Supreme Court. And actually, this is the 6th case that we have discussed, not 6th case, but 6 opportunities we have had to talk about cases that were before the Supreme Court. And a lot of people get to hear ahead of time to sort of watch how to expect what an opinion might be or just have knowledge about it. And for that, I have to thank Steve McAllister so much because he has done so much in that area. And I certainly want to thank all 4 of you this evening, in addition to Steve, for being with us. Thank you for your expertise, your time, your travel. Safe travel. Please give them a warm applause. Now that, our guest, was a warm, long applause. I didn't ask for all of that, but that's how much they enjoyed you. Thank you so very much. Good night to all of you and safe home.